Good afternoon. Our next case is Armistead et al. Versus County of Carteret. We'll hear from the appellant.
Good afternoon, Chief Justice and Associate Justices. My name is Sunny Haynes of Womble Bond Dickinson and the Forsyth County Bar. I'm here representing County of Carteret, the appellant in this matter. This matter is here from the trial court's order granting certification as to 3 classes in the trial court. These classes are the waste collection green box fee class, the landfill fee waste collection class, and the cost to operate class. The classes arose out of the plaintiff appellant's allegations that the county charged illegal solid waste fees, and the trial court improperly certified as to the 3 classes. In this particular case, Your Honors, the county has operated a solid waste management program continuously since 1995 and charges 2 fees related to that program. One is a green box fee that is an use fee within the meaning of Section 153A292B, and then the landfill fee, which is an availability fee within the meaning of the statute. So first, with respect to the green box fee, the trial court declined to certify a failure to use class. That class turns on the same evidence and the same issue of non-use as the green box fee waste collection class that the court did certify. And the court, in its order, cited to the EQT case from the Fourth Circuit, and that case has recently been cited by the Fourth Circuit in the Mr. D's case from earlier this year. And the court, in declining to certify the failure to use class, correctly determined that that class was not ascertainable. That argument applies with equal force to one of the classes that the court did certify, which is the green box fee waste collection class. And the reason that that class is not ascertainable and certification should not have been granted is because that class cannot be determined by whether they did or did not use the green box fees. It's very clear from the statute 153A292 that the green box fee is a use fee. So
Just
yes,
as a clarification,
yes, Your Honor.
Isn't that, though, under our standards? I mean, the Fourth Circuit's using the federal class action rules, and the way we've described ascertainability, which, because a lot of this isn't sort of from the text of our rule, it's court-created doctrine. And what I understand you're calling ascertainability now might be ascertainability under the federal doctrine, but isn't it the predominance prong of what we've looked at? So the idea would be this is going to degenerate into a whole bunch of individualized questions. We can't ascertain who all these people are. The problem is, in order to figure out if each one of them can win their case, we're going to have to answer all these fact questions that are specific to each of them, and that's the reason that we can't certify the class. Am I missing something, or is that the same argument?
No, that is correct, Your Honor. We've raised ascertainability as an issue of predominance, also commonality, and then the plaintiff cited the McMillan case from this court to say that it is a matter of superiority. But the problem of proof is the same, whether it's considered an issue of predominance or commonality or superiority. And what is clear from the case law from this court and from the Fourth Circuit is that the class should be identifiable. There should be reference to objective criteria to determine who is and who is not in the class.
So let me ask, because that was my first, just as a procedural question, I think it's paragraph 18 in the trial court's order says, the parties have stipulated that all discovery is complete. What does that mean? What does that mean? After this class certification order, next step is summary judgment? and if judgment's not entered as a matter of law, next step is a trial, but fact discovery is over in the case. Is that what that means?
What we've argued is that pre-certification discovery is over. The scheduling order in the case does not contemplate any further discovery. However, the argument related to the non-use that is a prong of the green box fee waste collection class, we would submit that there is further discovery, or at least the county would have a right to probe
Well, that was
claims.
my first question is, does that mean, if this at least at a minimum means that discovery on the class is over, does that mean that the parties have in their possession right now a list that came from these third-party waste service providers of every one of their customers, so that you can identify, because those would be the only people in the class, would be the ones that you somehow know, because I assume the county just doesn't have right now a list of these are all the people that live in our county that say they hire private service and don't.
That is correct. The county knows who paid the fee, but the parties do not have.
So
in
has
their
there been
possession
discovery of those,
of the haulers?
to know who those names are of those potential class members?
We know the names of the people who have paid the green box fee. We do not know who does not use the green boxes, and we do not have any information from the third-party waste collectors.
So to even know who the class members are, there's going to be a ton of discovery that still needs to be done in this case.
Yes, I would agree with that, Your Honor.
And then I assume your argument is it's more complicated with respect to that class, the second class. It's more complicated than to just say, we just need to know if you hired a private contractor to come and take your trash away, because those people, maybe that service comes once a month, and they just trash piles up. So several times a month, they go to the green box site and dump it in the dumpster. In which case, it seems to me under a fair reading of the ordinance, you would need to pay that fee. And that seems a lot like the fact question that your client prevailed on in the first class, which is it's going to degenerate into many trials where your client will say, I don't believe you. I think you did use the site. And then someone will have to figure that out. And that would be too individualized. That's your argument on that class?
Yes, Your Honor. You have touched on the core of the issue as to the green box fee waste collection class, which is that really the question does not turn on whether the property owner had a service. It turns on whether they used the green box fee sites that the county provided.
And so my understanding that right now the parties have no idea who hired those services, if it was continuous from 2017 on, if it was they hired, had for part of that time period and not others. None of that information is known at this time. Is that right?
Yes, correct. The only thing that we know is that for individuals who did apply for releases or refunds of the fee in previous years, we would have the documentation that they submitted in order to secure those releases and or refunds.
Right. So the people part of their argument is that you shouldn't even need to do that. But there could be some people who come in and say, I want my refund. Here's my proof that I've got it. Right. Okay.
Yes, and the issue that you've raised as far as non-use really is a core issue, because we're talking about claims that go back from 2017 to today. The plaintiffs have invoked a continuing harm argument, which means that we need to look all the way back to 2017 to determine not only if these individuals had another waste collection service, but also whether or not they used, or anyone in those households used, the green box sites or the landfill. That would be available as well, or the landfill during any of those years.
Well, that was going to be my next question. So I think you just answered it. So in the county's view, is it also the case that if you had the private waste collection service, but occasionally you would take trash directly to the landfill and deposit it, that you would have to pay that availability fee? Is that the county's position?
Yes, that is correct.
So that seems then like the same individualized fact question from the second class. You're not taking it to the green box site, you're going to the landfill, but still it would either entirely or at some point you would be permitted to pay or you would be required to pay the fee because you're using it. That is
the issue, and there's also one additional issue. The other issue with the availability part of the statute is that it turns on whether the landfill or the separate service offers the same service as the county. The plaintiff's argument is that it's the same service because the waste ends up in the same place. However, the issue is that the county collects waste that other collectors do not. We're talking about things like yard waste or batteries or scrap metal or paint. Those are all things that the private collectors do not actually collect because they're not considered recyclables. So the idea that the county does not provide a distinct service from these collectors is not borne out on the record, and the plaintiffs have not done any discovery to carry their burden to show that the members of the class do not use landfill services or benefit from the availability of the landfill as well. So it is the issue of the use, but it also turns on whether those same services are offered, and there's no evidence in the record that it is the collectors that provide the same service as the county.
It seemed to me that your friend is going to argue that the way you can draw a distinction between the first class and these next two is that it wouldn't require such an intensive individualized fact determination because you could just subpoena these collection services. And if, let's say, they submit their customer information and it's that, yes, for these people, we came once a week and took everything, then even if you say, well, I still think you went to, some of these people went to the green box site at some point, it's easier to resolve that fact question because you have all this proof that that's just not true. Why would you do that if you have a trash collector that comes every week? And that makes it easier and perhaps not as problematic as the first class, where you really would need to sit every single person down and have the jury look them in the eye and say, are you lying about saying you never went and dropped off trash here? What's your response to that?
That is what I understand plaintiff's appellee's argument to be. However, that is an oversimplified issue because the reference to the waste collector documentation would only show that the property owner had a service. It does not show that they did not use green box fees sites or that they did not use the landfill that they are paying the fees for. And we're talking about an area of the county that experiences tourism. It also experiences inclement weather. And so even though we have affidavits in the record from the named plaintiffs that say that they personally did not use the sites, we have no information that no one in the household used the site. We're talking about the property in total, not just the fee payer. So if any waste went out because there was inclement weather, the collector couldn't come through in time, or there were items that the collector would not actually take and dispose of, then it is certainly possible that those renters, those household guests, all of those types of individuals could have used these sites, and the household would benefit from the availability and the use of the sites, and the property owner may not even know that. And so the issue with having so many open questions is that we're talking about a period of time that goes back to 2017, and we would have a right to probe as part of the county's defense on whether there's use for each of those years where a refund is claimed, but also whether those same services were being offered in each year that the property owner claims that they did not benefit from the use of a landfill. And so what that would require is looking at those particular contracts with those waste collectors.
And this is only for the third class, right?
That is as to the waste collection landfill fee class. Yes, Your Honor, to the third class.
It does seem to me that the concerns you're raising essentially make the state statute unenforceable, because 153A-292 does say that essentially, it's a long paragraph, but essentially it says a county can't charge a fee to someone who has a private contractor. And I understand the same services issue, although it does go on to say that to the extent that services provided by the county disposal facility differ from the services provided by the private contractor in the same county, you can charge an availability fee to cover the costs of the additional services. But if you're saying essentially, well, even if someone has a private contractor, maybe somebody else in their house went to the green box, so therefore we can charge the fee, that would essentially eviscerate the statutory provision.
I do understand that concern, and that is a part of plaintiff appellee's argument. However, the county remedies that by providing the release mechanism. The county's position is that it is the fee payer on an annual basis who is in the best position to know whether or not that person has a collection service for the household and whether or not at least that person is using the landfill. They may not know about other individuals in the household. But the reason that the county provides that release mechanism, and it is mandatory, if a fee payer comes and says, I have a collection service, here's my contract, here's an email from the collector, there's various forms of documentation that have been submitted, but the county does not charge that fee. It will it will be released before the bill is ever paid. And there have been instances in the past where individuals have come back after paying the bill and they receive a refund because they present that documentation for the particular year.
Right. So if the county is administering this statute in that way, why wouldn't it also be appropriate to have a class of individuals who have a private contractor to take away their trash?
So as to the second class, it's because it still turns on the non-use question. I believe that the trial court was looking at whether or not a potential class member had a service, and that was the end of the inquiry. But really, it's not about whether the property owner had a service, it's really about whether that service was used, whether the household benefited from the use and availability. And then it's a similar argument as to the third class, but our core argument there is about the same services language of the availability portion of the statute. So it wouldn't be unenforceable to the extent that the county does not charge the fee if the documentation is required. And so there's no authority that I'm aware of, either statutory or in the case law, that requires the county to have any other system where it doesn't put the onus on the fee payer, just like the onus would be on the taxpayer under Section 105-381 of the North Carolina General Statutes to raise any issues with the tax bill. That's the tax remedy statute. And since we're talking about fees that apply on the property tax bill, we have a similar analysis and putting that burden on the payer to say they have the service because they would be in the best position to know. That is where the county's position is on charging the fee on the bill, even though it does not know who benefits from the service on the front end. Does that address your question, Your Honor?
Well, it does seem to me still, however, that that's essentially what the taxpayers here are trying to do. It's just that rather than individually coming to the county, they're saying, actually, we want to come as a class because all of us who contract with these private waste collection services should not have to pay this fee. So I don't understand why something would be a barrier to a class, but it's not a barrier to an individual.
It is, well, it's not a barrier to either because there have been instances where taxpayers come in after the fact, after they've paid their property tax bill and have applied for and received refunds. Now, that is not unlimited. I can't speak for the county on how far they would look back. Of course, the taxpayer remedy statute has a 3-year look back period. If we were to follow the quality built homes impact fee line of cases, that also has a 3-year statute of limitations from payment. So it's not a barrier because there is not only a release mechanism for the payer to be released from ever paying the fee, but then there's also the refund mechanism if the property owner pays the fee but then comes after the fact with documentation for a particular year.
So, just for me to clarify, because maybe I thought you'd answered about the sort of the statutory text something different earlier, but so let me circle back. I took that language in the statutes to mean when it says, this doesn't apply if your solid waste is collected by, someone else, another municipality or private contractor. I took that to mean if your solid waste is always collected in that way. So, for example, you couldn't, as kind of a loophole, hire a private service to come twice a year and then the rest of the time take it to the landfill yourself and not have to pay the availability fee. But do you agree with that, or are you saying, because I guess another reading of this could be if you pay someone else to come pick it up, you never have to pay that availability fee, even if you use the landfill. What's your understanding of it?
We did not argue it that way in briefing, but I find that availing, Your Honor, and I would agree with you that that is a fair reading of the statute, that if you had that service at any time, then you would not be charged the fee. But of course, if you're benefiting from the service, and really that's where we say that the issue turns on non-use, because if you receive a benefit from the service, then you can't fairly say that you've been an injured member of the class. And I've spent a lot of time on the second and third classes, so I do want to touch on the cost to operate class, and the argument there is very straightforward that there's only one case that I believe the parties have found in the state that really deals with the issue of the portion of the solid waste statute that says that a county cannot collect more than it costs to operate the solid waste program. And that's the Manning versus Halifax County case. That is an unpublished case from the Court of Appeals. In that case, however, there are a few things to note. First, it was a collection of plaintiffs that had paid 1 year of the solid waste fee pursuant to Halifax County Solid Waste Program. It was not a class action, and the county would not have been able to show historical losses over the life of the program because they were sued the very second year of the program. And what's important about that case is that the court stated that a full refund of the fees were due, and that's because they found that the county had violated the statute. So an illegal fee has to be refunded. And plaintiff's argument seems to be that the court would have to trust the county to refund the fees, but as I argue below, I'm not aware of a way that the county could state that if the fee is illegal, refunds would not be due to all of the individuals who had paid the fee relative to the cost to operate class. And the reason that raises superiority with respect to the class action context is because just a single claim, a single meritorious claim by a plaintiff would inure to the benefit of all of the taxpayers who had paid in any given year where the fee was found to be illegal. So to use the class action mechanism and the additional layers of administration and not to mention cost that are associated with presenting the case as a class action, we've argued that the class action mechanism is not superior to resolve that particular claim. A single plaintiff could prove that in a particular year that the county collected more than it cost to operate the program. And if that were the case, then a full refund would be due. So that is our argument as to why the class action mechanism is not superior to individual claims, and certainly why it is not a reason to use the extraordinary mechanism of class action, because we know that the general rule is that lawsuits are brought on behalf of individuals. The class action mechanism is extraordinary in that respect. And so here, with the cost to operate class, there's no reason to use the class action mechanism.
So can you point us to some law that would say that if a single fee payer establishes that the county overcharged, that the county would have to essentially refund everybody?
I would cite to the impact fee line of cases, but I would also cite to Manning versus Halifax County itself, because the court ordered a refund in the neighborhood of $1 million, and those few plaintiffs who brought that action did not pay $1 million to Halifax County. So the fact that the court said this is the recovery, all of that money was not going to those plaintiffs. It had to be refunded to the individuals who actually paid the fee. So that is what I think Manning versus Halifax County has to do with the class action context, that it tells us that the class action really isn't necessary. With one plaintiff could bring this claim, and there could be refunds on behalf of all of the members who had paid in a particular year.
If the county's exposure is the same, regardless of whether it's a class action, then why are you fighting the class action?
Well, the county's exposure is the same, Your Honor, but it certainly dilutes the recovery of the plaintiffs to have to deal with the administrative costs of the class action method. And although the cost to the county would be the same if there were liability, the question is whether the requirements of Rule 23 have been met at the class certification stage. And if the class action mechanism is not a superior method to adjudicating individual claims, then the class should fail, and the class should have been denied on that basis alone. So what we're really concerned with here is not the liability, but the Rule 23 analysis.
But am I right that on this question, the issue is whether there was an abuse of discretion, right?
Yes, that is the standard, Your Honor. Yes, and our argument.
I'm sorry.
Yes, sir.
Didn't we address this in Surgeon though also? So the other reason that there could be a superiority problem is if it ended up that all of the class members, the cost was to administer the program, what they charged was more than what it actually cost, but by such a small amount that divided over all the people in the county that are the class members here, they're getting pennies, but the lawyers are getting paid a lot of money. And then the argument would be, well, that's not an efficient use of the class system. That's not what class actions are intended to do. And that, it seems, I understood that to be your argument. We recently reaffirmed that in our surgeon decision.
Yes, I would agree with you there, Your Honor, and I think.
But isn't the problem with that argument that we really don't know at this point? I mean, you have to get through the case to know the answer to that question. How much does it cost to administer these sites?
I think that's fair to say, and I think in the surgeon case, the issue is 29 cents, or maybe there was a case cited where it was 29 cents, and I don't think we could argue that it would be quite that minimal. However, I would point to surgeon for one other point as well, which is that in that case, this court held that the court's analysis addressed a different class than the one that it certified. And so what I would argue there is that if the trial court evaluated ascertainability and predominance using the private subscription or having the private service as the key issue, when really the issue turns on non-use, then there's a mismatch between the evidence that was presented at class certification and the class that was actually certified, particularly with respect to the green box fee waste collection class, based on that whole issue of non-use. So we would argue that surgeon is also instructive for the proposition that there's been a mismatch between the evidence presented at class certification and the class that was actually certified.
But I want to go back to the cost to operate class and whether whether the trial court abused its discretion in concluding that this was a superior method of resolving the question. And it seems to me that on the flip side, if each individual taxpayer is only getting 29 cents, it certainly makes no sense for any single individual to challenge the county on this. I mean, who's going to go through the cost and expense and time of a lawsuit for a 29-cent recovery? And that's why actually class actions in this context make sense, because overall, everyone in the county shouldn't be overcharged.
I certainly understand that point, Your Honor. We're not talking about 29 cents here.
Okay.
In any given year, we would be talking about a refund of the green box fee that was paid, and I think the plaintiffs would probably also be asking for a refund of the landfill fee that was paid as well. And so although it's not 29 cents, it is a refund in every year where the county collected a profit. Plaintiff's argument would be that that would be 2016, or in the class period, it would be 2017 through 2021. So we're talking about the green box fee, which varied between $157 to $165, and then we're talking about that over a number of years. So you certainly are not talking about just $150, but of course that would hinge on the plaintiff proving liability. But since we are talking about multiple years where they have alleged that the county collected a profit, that certainly takes us out of the realm of it being just too small of a recovery to be worth it, particularly when everyone in the county would receive a refund if the fee were found to be illegal.
So this is still on the cost to operate class. So if the county is found to have overcharged, and you said, well, the county is going to have to refund everybody who paid, aren't you going to have to go through this identification process at that point?
For the cost to operate class,
Yes.
No, Your Honor, because if that fee were illegal, then it would be a refund to everyone who had paid the fee in that particular year.
But you would have to identify who those people were.
The county does know who paid the fees. The county does not know who doesn't use green box sites. The county does not know which haulers, well, the county does know, but the county does not have the evidence in the record of which haulers provide which services. However, what we do know is we know who paid the fee.
So I'm struggling with the superiority argument with respect to that group. If you already know who's in it, I'm struggling to see.
Well, we know who paid the fee, but the issue with superiority is that if one person were to challenge the fee and it were found to be illegal because the county collected more than it cost to operate the solid waste program, then the fee would have to be returned. And that would be based on the only authority that I'm aware of, which is the Manning versus Halifax County case from the Court of Appeals. Now, that is an unpublished case, but I think in all of this court's jurisprudence along fee cases, particularly involving local government, I think it would be fair to say that the county would have to refund an illegal fee, and in fact, there's statutory authority for that as well.
Counsel, you're well within your rebuttal time.
Yeah, thank you. May I reserve my 1 minute?
Mhm.
Thank you.
We'll hear from the appellee.
Mr. Chief Justice, Associate Justices, and may it please the court. My name is Matthew Quinn. I'm a lawyer at Lewis & Roberts here in Raleigh. I'm here with my law partner, Jim Roberts. I'm here with co-counsel also, Marty Gear. Together we represent the plaintiffs' appellees in this case. As the court knows, this is a case about two modest fees. There's a $15 fee, a landfill fee, and there's a $157 to $165 fee, depending on the year, called a green box fee.
So I'm going to interrupt you because we know all this, and I've got a bunch of questions, and I want to make sure you've got time for the important stuff. So can I want to start with, I'm actually more confused now, I think, than when I started. So help me out here. So have you not yet subpoenaed all these? I think your friend called them the haulers. Have you not subpoenaed them for their customer lists yet?
We've subpoenaed the haulers, and we've received the customer list from the haulers.
So you do know who it was that, and they all have records on this.
They all have records. They provided us their customer lists in response to our subpoenas. So I think that's point number one in response to that concern. Point number two in response to that concern is, to our knowledge, following an extensive amount of research, there is no case law that requires us to identify all of the class members or putative class members prior to certification. As
soon as it's certified, you need to give them notice.
Well, that's certainly true.
So you do need to have some idea of who they are. How are you going to give them notice?
So that's a fair point also. So, but the way it could work, and there's a lot of case law that supports this, is the county knows already, and we know already, everybody who should get that notice, right? We know who paid the green box fee. We know who paid the landfill fee. These people should get the notice. And then those individuals have documents in their file which would answer whether they're in the green box fee class. It would answer whether they're in the landfill fee class.
Documents in their file, you mean they would know whether or not they had paid one of these haulers
I didn't mean to interrupt, but that's exactly right. So the individuals.
So what would happen then if you get a bunch of class members and they send the form back in or whatever needs to be done with the notice protocol, and they say, yes, I think I'm a member of the class, and then you cross-check it with your list of the haulers and you don't see their name? What's going to happen?
Well, I mean, I think the trial court would have management responsibilities over that, would have the discretion for how to determine whether or not those individuals should be in the class or out of the class. And that's an issue. I mean, during the class notification phase, the trial court has, which is one benefit of a class action process, by the way, has wide discretion to supervise the process to make sure people that are going to be in the class are in the class and people that shouldn't be. But I think what my friend misses.
But I guess what I'm saying is, why wouldn't it be that the class is just if you have their names, the members of the class that you are going to notify are just the people from the records that you've obtained from the haulers, who are the only private contractors on record in this county, all of their customers? Why would it be broader than that?
Well, so in other words, if I understand, I'm not trying to ask you a question, obviously.
No, help me understand.
Yeah, so your point is, why couldn't we just use the names on the customer list provided by the hauler?
Right. Why wouldn't the court say, this is the universe of potential class members, notify these people, and that's what the class, in the order, it says the class I'm certifying is the people that use these services based on the discovery that's been conducted, et cetera, et cetera.
Yeah, I mean, I think that could be a viable approach, candidly, Your Honor. I mean, that certainly might address the situation. But also, I mean, we don't know the extent to which the customer lists from the haulers are always accurate. We don't know the extent to which maybe Jeannie Smith has been married and now she's Jeannie Jones, and there could be a difference.
Well, and that's exactly I think this gets into your friend's argument, because as soon as you have to start figuring out, are you telling the truth when you say you could get into the predominance problem of, okay, this is going to start to degenerate into a bunch of trials, because if someone says, yes, this is true, and the county says, I don't believe you, the only person that's going to be able to resolve that is a fact finder.
So this is one thing that I think the trial court did a really good job on, right? So during the hearing transcript, the trial court talked about his concerns with the failure to use class. And what the trial court was worried about with the failure to use class which has not been certified, and we did not appeal the decision not to certify it. But in the failure to use class, it depending on the individual saying, yeah, I never used the green box site, and therefore maybe they could just sign an affidavit and they would then get their check or whatever. The trial court made clear in the trial transcript that he was concerned about that with the failure to use class, but with the waste collection classes, which is the green box waste collection, the landfill waste collection, that's not a problem with those two classes, because the individuals who have paid the green box fee or the individuals who have paid the landfill fee, there's going to always be documentation in their file or which they can obtain to present to be able to say, look, I have waste collection service.
So you and I are tracking completely.
Yeah.
And so when I read the trial court, because I agree with you, it's very well reasoned and shows this trial court knows exactly what the predominance and commonality requirements are, because looks at it in this class, says, I can't, but then looks at the next two and says, I think I can. But what surprised me is I would have expected to see the definitions of the class for those two, then use that logic and say, and who am I certifying? Just the people who can prove through the documentation from these haulers that they have the service. And that way there will never be fact questions, because the county's not going to, I mean, I suppose the county could say, I don't believe you, hauler, that this is your business records, but that's, that's so implausible that I think that would be the reason there's no risk of a predominance problem.
Yeah. So, I mean, we believe, and it would certainly be our contention, that these classes are clearly defined, and you can determine who's in the class and who's not in the class with reference to objective criteria, and that there's going to be documents that exist either in these class members' files or with the waste collection company, which shows are you in or are you out. For instance, in the green box fee waste collection class, the class is clearly defined as if at any point through the date of the judgment you paid the green box fee and you have waste collection service. And the trial court will have discretion to determine, well, how do you prove if you're in the waste collection class? And our thinking on it and what the trial court said, and this does make a lot of sense, is they'll have a contract with the waste collector. They'll have a receipt. They'll have a proof of payment. Your Honor has raised a legitimate point. Their customer lists also. Are the customer lists accurate? I mean, I suspect they are, but there's going to be actual documentation that also proves this in the possession of the class members, which eliminates the risk of fraud or fraudulent claims or whatever else, which is what makes.
What about your friend's other main point, as I understand it, is that the county reads the ordinances to say, if you had the private service, but then you still use the green box or you still use the landfill, then you still have to pay. What's your response to that?
Yeah, so that was what I was going to lead with earlier when I first got started. That was going to be my first point. And this is the most fundamental point I want to make during my argument. I hope when I leave, this is the main thing I can leave with you. This case does not turn on whether anybody ever drives out to a green box site and deposits trash. It doesn't turn on that whatsoever. If you look at the green box fee waste collection class, that is based around the county's ordinance. The county's ordinance at issue is section 14-56. It is in record page 112. That ordinance, I'm going kind of fast, I see people are flipping, but that ordinance authorizes the county to charge a green box fee only to, quote, each residential household in the county which does not have household waste collection service, end quote. Now it goes on, in fairness to the county, to clarify that they're talking about unincorporated areas of the county. I'm not disputing that. But the point is...
So let me give you the hyperbolic, hypothetical scenario. So your position is that the plain text of this ordinance means if you hired a household waste collection service to come once a year and then use the green box the rest of the time, that you don't have to pay the green box fee.
So 2 points in response to that. Number one, I'll answer your question directly. I think that's exactly what the ordinance says. That's number one. Number two, I think that's a merits issue. And today, and I know we have to talk a little bit about the merits so that we can have read from the same hymnal about what the basis for the classes are. I understand that, but getting into that granular level of detail, that's something that's a merits issue. The trial court will deal with that issue at summary judgment, and they're absolutely, should this court affirm the certification.
But what our case law holds is if there's a merits question in the sense of what is the proof that's going to be necessary to prevail on the claim, that you can resolve those legal questions and know what will you have to prove in order to determine commonality and predominance. So, I do think, but I agree with you. Like if you're being, channeling your inner Justice Scalia here and being a total textualist, you would say, yes, that is exactly what these words say. But I do think a very fair reading of this is assuming that when they say, which does not have household waste collection services, that what that means is that regularly come and take, and that if you're someone who, for example, half the year you had it and the other half you didn't have it, maybe you're just going to Carteret County certain times of the year and then you might visit, but those times when you go and you don't have the service, you go to the green box, you would need to pay the fee. What's the...
Yeah, so two responses to that. So number one, the case law of our state is that a county's ordinance is legislation for that county. So the county's if a county goes outside of its ordinance, the county, in the case particularly of charging a fee, the county is behaving ultra vires if it charges a fee which is in violation of its ordinance. So the ordinance clearly delineates what the fee the county can charge. The county is allowed under the ordinance to only charge the county is not empowered to charge households that have private waste collection for the green box fee. And from our perspective, as to the green box fee class, that ends the analysis. You don't have to go look at the statute and look who's going out to the green box sites. You don't have to go do that because the county under the ordinance didn't have the authority to charge the fee in the first place. So that's point number one. Point number two is the depositions or substantial portions of the depositions that were taken in this case are part of the record on appeal. Mr. Foxworth, who was the assistant county manager, Ms. Davis, who was the tax administrator, Ms. Meshaw, who was in the finance department, all of these individuals are involved in billing for green box fees. They were all deposed. All of them said, myself and Mr. Roberts took these depositions. They all said, we asked them, now under your ordinance, you're not allowed to bill somebody. You're not allowed to collect a fee from somebody, are you, if they have private waste collection? And to a person, they all acknowledge, yes, that's the case. Now, their comeback to that is, but we don't know who has private waste collection. And of course, I know your honors have read the briefs. Y'all know what the comeback to that is, which is there are many other counties. The School of Government has actually issued advisories about how counties should charge these fees and do it consistent with the statute. And other counties charge you to put a sticker on your car, or they charge you per use to go out to the green box sites. And so other counties actually have a good system of keeping track of who can be charged a disposal fee. But the point that I'm making is, I understand your honor's point about the ordinance, but the ordinance says what it says. It's clear and ambiguous in what it says. And during the depositions, every person with the county we talked to, under oath, admitted with what I'm saying. Specifically, you don't owe a fee if you have private waste collection at your home. So I think that's the best way I know how to respond.
Right. Well, and I suppose the other argument is my hypothetical is such a corner case that it's unlikely there'd be many class members in that situation. And again, it would have to be that the individualized issues would predominate. And if you just have a couple people where that's a problem, maybe they're just not in the class, or it doesn't become an issue that predominates.
And I think that's a very fair point, and perhaps that's the first thing I should have said. But yes, I also agree with that. It's got to predominate over the class. And if it's going to be so, I'm not aware of any evidence in the record. Actually, I think I can be stronger than that. There is no evidence in the record that suggests that people have waste collection like once a year or once every 6 months or anything like that. I mean, and another thing I want to be clear about what we know about these other private waste collectors is we've come forward with, when I say we, I mean plaintiffs, have come forward with substantial evidence about exactly how these other private waste collectors operate. We've come forward with evidence that there are 7 of these private waste collectors operating in the county. We've come forward with evidence that all of these private waste collectors, what they do is they take their trash to the Hibbs Road transfer station in Carteret County. We've come forward with evidence that that is precisely the same transfer station that the county takes its trash to. We've also come forward with evidence that the entity, the co-op that owns the Hibbs Road transfer station, then transfers all of the trash put there, whether it's from a municipality, whether it's from the county, whether it's from a private waste collector. It takes all of that trash and then moves it over to the landfill at Tuscarora, at the Tuscarora landfill in Craven County. So, as to the issues about the landfill fee class, landfill waste collection class, and whether all these entities are, whether these private waste collectors are offering the same services. They are. I mean, we know that all of the waste collection companies are using the same transfer station the county's using. They're using the same landfill that the county's using. It's the same services that is being offered for all of them. And so what that therefore means is that under the statute, 153A-292, the county does not have the authority to charge those individuals that have those private waste collection companies with a landfill fee or an availability fee.
So I think I've heard your friend argue that with regard to the fourth class, that would be a significantly larger group where one person could bring the lawsuit and there's a finding that the profits were unlawful, and so then the county would automatically refund. Why is it the best or the appropriate use of this class action to include a group much larger than the second and third classes?
Chief Justice Newby, I appreciate that question. You know what I understand the county's argument to be, and what I understand your question to get at. And if I get this wrong, let me know, and I'll try again. But it basically what the county is saying is one person can go to court. They can, if they prove the fee is invalid, everybody in the county gets a refund of their fee. And I think there are a few responses to that. Number one, the county referenced the Manning v. Halifax case and suggested that in that case, a small group of plaintiffs prevailed in invalidating a fee and everybody got a refund. That's not accurate. I've read that case 20 times. The way that case turned out is the named plaintiff in Manning v. Halifax, the named plaintiffs, and it was like 20 of them, but the named plaintiffs in that case got their refund. I don't read that case or understand that case as suggesting or allowing like one plaintiff to go to court, file an action to invalidate a fee, and then everybody that paid the fee gets a refund. I don't read that case like that at all. That's number one. Number two, that is an unpublished decision for whatever that's worth. Then number three, my friend Mrs. Haynes suggested that the impact fee cases have allowed a single plaintiff to file an action and get a refund for everybody. That's respectfully, I don't think that's accurate either. I've read all the impact fee cases as well. None of those cases allow a single plaintiff to file a lawsuit and get a refund for everybody.
I'm sorry.
Yes, sir.
I thought you were done, but I was going to say that the one that seemed to concern me was it, if I was to go back and file a lawsuit, some kind of DJ action, and say, the county where I live, you collected, excessive fee from me in 1979. They would say, buddy, that was too long ago. You can no longer bring this claim, and who knows how long this lawsuit might take to be adjudicated. But at the end of it, if the county then were to say, no, I'm not going to refund these other people, I don't think that's really you, or I don't think you paid it, or whatever, there may be putative class members now that would find that it's too late. And so your argument, as I understood it, is you're just trying to protect all the class members now and ensure the county just does what it claims it's going to do at the end of the case.
Yeah, I mean, you kind of read roadmap of where I was about to go. I mean, the next point is Rule 23, the class action order, has a lot of protections built into it for the named class members, putative class members, but also I mumbled that. Rule 23 has a lot of protections built into it for the named plaintiffs, but also for the putative class members who are not actually in court. So, for instance, the named plaintiffs they can't have a conflict of interest with the putative class members. Another example is they have to adequately represent the putative class members. Another issue is that the trial court, as I alluded to earlier, under Rule 23, has supervisory authority over the class action and has discretion to determine the class notice and how it's administered and all this other stuff. If it was just one plaintiff who went to court and filed a lawsuit, none of those protections would exist. And I mean, I want to, give a little bit of an absurd example, but I think it illustrates the problem that I'm talking about. Like, let's suppose hypothetically that, like, the town man, and I'm not suggesting the town manager would ever do this, but let's just say the town manager went into court, filed a lawsuit over this fee, and then settled it or resolved it for 50 cents, right? I mean, so is that supposed to be binding on everybody? I mean, there would be an obvious conflict of interest there that could not exist in the class action context.
Right. And I think this came up, I think this was in the argument. It is not in our opinion in the Jackson case that we just issued, which is another class action case where the same argument came up. But I believe the plaintiffs there asserted that offensive collateral estoppel might not necessarily even apply. And so, for example, you might win the first DJ action and lose the second, or vice versa. And it's that sort of inconsistency that would be another reason to just the efficiency of doing them all at one time.
That's right. Your Honor, I agree. And all of the, or I shouldn't say all, most of the class action opinions from this court talk about certain benefits of a class action being judicial economy and also avoiding inconsistent results. And it's certainly possible one plaintiff could go into court, could prevail that the fee is invalid, and another plaintiff come in and, for whatever reason, the fee, different judge reaches a different decision. So the class action mechanism, in addition to protecting the class, and it also creates judicial economy, it prevents inconsistent results, it has a number of benefits. And then I also just want to mention there is no case cited in any of the briefs, which stand for the proposition that one plaintiff can go into court and get a refund of a fee for everybody outside the class action context. I'm not aware I'm virtually certain there's no case in North Carolina to that effect. I'm not aware there's any case anywhere to that effect. I mean, there was one case cited by there was only one case cited by the county for this proposition in its brief. It was the Nelson v. Mustian case. That's out of the Northern District of Florida, so it's a federal district court case, and it did not involve the refund of a fee. I mean, it was a declaratory judgment, so it's totally distinguishable and inapposite here. I also want to spend some time talking about the green box fee, the superiority issues raised by the county with respect to the green box fee waste collection class. The county has stated that there is and I heard the words used earlier, and they were said in the brief, that there is a refund provision in the county's ordinance, which supposedly, what the county has asked the court to do is to overturn the trial court's exercise of discretion, tall order, overturn the trial court's exercise of discretion and determine that this refund provision in the ordinance is superior. I want to be really clear and emphatic about this. There is no refund provision in the ordinance. None. In the county's interrogatory responses, the county said, quote, that this ordinance is, quote, not a refund provision, end quote. That is on record page 165. So the county, in its brief on pages 30 to 31, says, there's this refund provision. That's the superior mechanism to a class action. People can apply for a refund. I heard that a minute ago in argument. That is inaccurate. The county has said in its verified interrogatories on record page 165 that it's not a refund provision. That exemption provision appears in the ordinance section 14-57. That's on record page 112. It is clearly not a refund provision. It allows individuals to apply for an exemption on having to pay a green box fee, and they have to do it every year. They get the bill. They get the bill according to the ordinance approximately on August 1st of every year, and they have until January to apply for the exemption every year. And according to this exemption provision, they even have to go and get a certified document from their waste collector, that they have waste collection service. So we're in the world here of a superiority analysis where a trial court has discretion to determine whether the class action mechanism is superior to other mechanisms. And given the onerous nature of this exemption provision and the fact that it is clearly not, by the county's own admission in its interrogatory responses, not a refund provision, I would suggest the trial court was well within its discretion to determine that the class action mechanism is the superior form of adjudication in this case. I'm going to jump around a little bit now and clean up just a few things that I missed in response to great questions. Okay, this is what so the court has kind of been there's kind of been an invitation by the county for the court to make a determination about whether there is an administrative feasibility requirement in North Carolina. We would say a few things about that. Number one, the court does not have to make any holding about that to resolve this case. And the reason the court doesn't have to make that holding is because the documents that would be in the possession of the people in these class, the waste collection contracts or waste collection receipts or proofs of payment or whatever, that by itself is administratively feasible. So it's really a red herring issue. There is no need for the court to enter an order saying, for now on, an initial hurdle to certifying a class is there has to be administrative feasibility. We don't have to go there in this case because there is no administrative feasibility issue in this case because the documents are in everybody's file, or you can contact the waste management company and get the documents from them. So that's the first thing I would say. The second thing about the administrative feasibility issue is that is the county's argument that administrative feasibility is a initial prerequisite to getting a class certified. That is a distinctly minority position, distinctly minority. So this court in the McMillan case talked about class identification issues and administrative feasibility in terms of a superiority analysis, which is a discretionary issue. The trial court can decide yes or no whether to even consider that. And the trial court has discretion about what's the superior option. So the McMillan case, we would suggest, just decides that issue. But in the federal court system, the vast majority of federal circuit courts have determined that administrative feasibility is not a mandatory prerequisite to class certification. We cited these on page 40 of our brief, but the Second Circuit, Sixth Circuit, Seventh Circuit, Eighth, Ninth, and 11th circuits all hold that administrative feasibility is not a mandatory prerequisite to class certification. I would suggest, having read all these cases, that the most thorough and for somebody like me who needs something really clear, a really clear explanation, was by Chief Judge William Pryor in the Cherry v. Dometic Corp case. That's out of the 11th Circuit. And Chief Judge Pryor explained how administrative feasibility is something that a trial court can consider. I mean, it's a federal case, so he calls it the Rule 23B analysis. Here, I think we would call it the superiority analysis. So, but the point is, Chief Judge William Pryor talks about how administrative feasibility is something the trial court has discretion to consider, but isn't required to, and it's certainly not a prerequisite to getting a class certified. So, unless the court has any other questions, we would respectfully ask the court to affirm the class certification order as a proper exercise of the trial court's discretion. And the final thing I will say is that the court has repeatedly indicated that honoring a trial court's discretion is the touchstone of appellate analysis, and we think that that's particularly appropriate in this case. Thank you very much.
Thank you, counsel. Rebuttal.
Thank you, Your Honor. So the plaintiffs say that the class members can be identified with reference to the tax rolls, the hauler lists, which are the list of customers, and affidavits. I misunderstood your question earlier, Justice Dietz, about the information within the party's custody. We have information about the customer list. What we don't know is individually on a contract level whether those are the same services that the county offers, and we would contend that they're not. So the plaintiff's theories require us to separate year by year on a property by property basis who did not use or benefit from the county's convenience sites. And that's everything from the property owners themselves to family members, guests, or potentially renters as well. And what the ordinance actually says under section 1456, it says that the availability fee may be charged based upon optional use privileges. So that was the part that you didn't hear of the ordinance, optional use privileges. So we asked that the classes that were certified be reversed. Thank you, Your Honor.
Thank you, counsel. Clerk.
All right.